What if the way you think about Uber is legally wrong? If you thought Uber drivers were simply independent contractors paid through an app, this case might change how you see it. Today we are unpacking one of Australia's most significant tax and gig economy rulings, Chief Commissioner of State Revenue and Uber Australia. In this story, we'll review how Uber operates its business turned into an $81 million legal showdown. We will also discuss what this means for the future of platform businesses, regulators, and workers in Australia. Let's jump in. In mid-2020s, Uber explored across Australia, disrupting taxis, reshaping city transport, and redefining what is meant to work. But behind that sleek technology and flexible mode of business, tax authorities were asking a basic question. Who is actually paying who and for what? Between 2015 and 2020, the New South Wales Chief Commissioner of State Revenue issued payroll tax assessments against Uber Australia worth around $81 million. Their reasoning? Uber was paying drivers for or in relation to work and relevant contracts, triggering the payroll tax under the legislation. It's called Payroll Tax Act 2007. Uber, of course, disagreed. They said, "We don't pay drivers for work. We are just the payment agent. Drivers work for passengers. We simply facilitate the transaction." At the first instance, Justice Hammerschlag in the Supreme Court largely sided with Uber, holding that those payments weren't for or in relation to work. The Commissioner appealed, and in August 2025, the New South Wales Court of Appeal flipped that decision. The Court of Appeal's reasoning on the following three issues has now become the gold standard for how courts think about gig economy arrangements in Australia. Firstly, understanding the Payroll Tax Act 2007. What is the legal engine behind the case? Before we dive into the juicy part, the courtroom debate, let's decode the law that started all. Because without understanding the Payroll Tax Act 2007, the Uber case sounds like another fight over definitions. Number one, what payroll tax actually is. At its core, payroll tax is a state tax on wages paid by employers to employees. Sounds simple enough, right? Until you meet modern business models like Uber, where no one calls themselves employer or employee. That's where the deemed employment provisions come in. These are special rules to stop businesses from avoiding payroll tax by using contractors instead of hiring staff. Let's unpack the three powerhouse sections that decided the Uber case, being Section 32 to Section 35. Section 32 is the relevant contract test, and it is where everything begins. It says that even if a worker is not technically an employee, the contract can still be a relevant contract if one party, being the contractor, performs work for another party, being the principal, and the payment is for or in relation to the performance of that work. That means if Uber drivers are providing driving services for or to Uber, the law pretends that Uber is the employer and the driver is the employee for tax purposes. But there is a twist. There are exemptions. Section 32, subsection 2, subsection A is about the ancillary to goods exemption. This is the clause Uber leaned on. It says, contract is not a relevant contract if the services supplied are for or in relation to performance of work that are ancillary to the use of goods which are the property of that person. In plain English, if you are supplying a service that's just incidental to using your own tools or machinery, like a contractor using our own bulldozer, that might be exempt. Uber argued driving is just ancillary to using the driver's own car. As we will see later, the court didn't buy that. Section 33 and Section 34 tell us what happens once a contract is found to be relevant. Those clauses say the principal, here Uber, is deemed to be the employer. The contractor, being the driver, is deemed to be the employee. If the work is supplied to Uber, then Uber becomes a deemed employer. Finally, Section 35, subsection 1 seals the deal. It says wages include any payments under relevant contract that are for or in relation to performance of work. That's the money test. If Uber's payment to drivers are linked to their driving, taking into account distance, duration, or trip performance, they count as wages. With the understanding of these relevant provisions, we will now look into how these three key legal issues are debated in the courtroom. Issue number 1, is Uber a marketplace or part of the driving service? Here's the first big question. Uber argued that when a driver gives a ride, the service is supplied to the passenger, not Uber. According to Uber, it is merely a technology platform. It connects driver and rider, processes payment, and deducts a small fee. That's been Uber's legal stance around the world. We are a platform, not a transport company. So Uber's submissions in court can be summarized in 4 points. Firstly, drivers provide services to riders, not Uber. Secondly, Uber is just marketplace earner, like a nanny introduction agency adopting Uber Council's analogy. Thirdly, the driver contract doesn't require any driver to perform a trip. It merely gives access to the driver app, and that app creates an opportunity, not an obligation to drive. Fourthly, therefore no driving service is actually supplied under that contract to Uber itself. They pointed to Thomas and Nas, where doctors working at medical centers were found to also perform services to that practice. Uber insists that its case was different. Drivers can reject or cancel trip requests anytime. Sounds reasonable? So what does the Chief Commissioner say? The Commissioner countered that Uber's business exists only because of the transportation by drivers. The Commissioner's point is that the driving service is supplied to Uber as well as to riders because it generates Uber's service fees and enhances the value of Uber's app. Whether a driver could cancel trips or lacked a direct contract with riders was irrelevant. The relevant question was, what's the relationship between Uber and the driver? The answer by the Commissioner is that the driver provides human service to Uber and certain contracts, which is deemed as the employer-employee relationship for the purpose of the Payroll Tax Act. Now let's look at what does the court say. The court found that the driving service is supplied to Uber and the driver contracts for 3 key reasons. Firstly, Uber's revenue depends on drivers performing the services. Without drivers accepting trips, there is no fare, no commission, no business. The act of driving generates Uber's income. That direct link matters. Secondly, Uber controls and shapes the service. The contract gives Uber rights over pricing, trip allocation, and payment flow. Even if drivers can reject rides or use other platforms, their service feeds directly into Uber's business model. Thirdly, substance is more important than form. The court said it's not enough that Uber calls itself an agent. In substance, the driver's performance enables Uber to deliver its own promise to riders. That's supply under a contract. The court said the real issue isn't whether drivers are legally bound to drive, it's whether when they do drive, that service is one supplied to Uber under the contract. Transportation of riders, the court said, is not merely of assistance to Uber in some indirect way. It clearly generates a financial benefit and is the foundation of Uber's business. That one line changed everything. This reasoning signals a broader view of supply and a contract. Traditionally, courts looked at direct contractual privity, who is the legal counterparty. Here, the court zoomed out to economic function. It essentially asked, who benefits from the work? If the answer is Uber, then Uber is the recipient of the service, regardless of contractual span. That subtle shift has huge implications for all platform businesses, from food delivery to home service apps. If your business revenue depends on contractors performing work for end users, you may be receiving a service under contract in the eyes of the law. This means the platform can't hide behind "we are just an app" label. Now, let's look at the second issue, whether payments were for or in relation to work. Here's the million-dollar question, or rather, $81 million one. When Uber pays a driver, is that really for work? What's Uber's argument? At first instance, Uber convinced the trial judge that payments to drivers were not for or in relation to work, because Uber was just passing on money collected from passengers. Putting another way, it's just like an intermediary, a collection agent. It collects the fare from the rider, deducts its commission, and passes the rest to the driver. So Uber claimed those payments aren't for work done for Uber. They are simply money in transit. Uber even warned that if the court finds a relevant contract under Section 32, that doesn't automatically mean every payment becomes wages under Section 35 of the Act. The trial judge created a test. the reciprocity or calibration idea, meaning payments had to directly correspond to work done for Uber to count. Since such element is missing, the trial judge sided with Uber and ruled that those payments to drivers were not considered as wages under Section 35. The Chief Commissioner argued that this reading guts the purpose of Section 35. The phrase for or in relation to performance of work is meant to be broad, covering any payment that has a work-related connections, direct or indirect. The Act doesn't mention reciprocity or sustainable calibration. Those were terms invented by the trial judge. Even if such calibration were required, the Commissioner was of the view that they clearly existed. Drivers' pay correlates directly with trip time and distance. The Court of Appeal overturned the trial judge's findings. The court said the payments by Uber to drivers are payments related to the work performed by the drivers in transporting riders. There is, thus, a direct relationship between the performance of work and what was payable. The court has made few observations. Number one, payments were calculated by work metrics. Every driver payment is determined by trip time and distance, the exact measure of work performed. That alone ties the money to work. Number two, Uber's agency role doesn't break the chain. Acting as a collection agent doesn't mean Uber isn't paying for work. The money flows through Uber, it's still a payment in relation to work. Number three, in relation to is broad. The court said the phrase is deliberately expansive. It captures indirect relationships, not just the strict employment payments. Number four, reaffirmation of precedent. The court relied heavily on Optical Superstorm and Thomas and Nas case, where similar arrangements were held taxable. In short, the court rejected formalism. It looked at economic reality. Drivers work, Uber benefits, Uber pays, payroll tax applies, and added that Uber's role as an agent didn't change the character of the payment. Whether Uber collects on behalf of riders or not, the money is still for the work done. So what's the practical takeaway? Well, this findings essentially expands payroll tax to gig-style contractor networks. It tells businesses, if your contractors are doing work that earns your income, expect those payments to be treated like wages. It also rejects Uber's platform neutrality myth, the idea that it's just a tech intermediary. The court said, if you profit from work done, you are economically participating in that work. Now, let's look at the third issue. What's the scope of exemption? Is driving ancillary to using a car? Have you heard Uber drivers said to you, I drive Uber not because I want to make money. It's because I love driving. I love speaking with passengers and this kind of freedom. That's exactly what Uber tried to argue in its favor. Uber's argument was clever. They said drivers aren't really providing a driving service. They are just providing access to a vehicle, using their own assets to transport passengers. Uber leaned on Section 32, subsection 2, subsection A of the Payroll Tax Act and say the contract isn't a relevant contract if the service supplied are ancillary to the use of goods which are the property of that person. Uber said drivers use their own vehicles, being their own goods. If the driving service is deemed supplied to Uber, it's ancillary to using those cars. Therefore, the exemption should apply. In other words, the real thing being supplied is the car's use. Driving is just incidental. The commissioner shot back, saying there is no separating the use of the car from the service of driving it. Both Uber and the rider benefit differently. The rider from transport, Uber from its service fee. But in every case, the driver uses their own vehicle to perform the driving service. That, the commissioner said, is one inseparable activity, not two. The court agreed to the commissioner's submissions. The court rejected Uber's linguistic gymnastics that the intangible service Uber receives is somehow ancillary to the tangible car use. Those distinctions were termed as artificial. The court held that the driving service and vehicle use are inseparable and practically intertwined. Thus, the exclusion in Section 32, subsection 2, subsection A didn't apply. The court went out making few findings. Number one, driving is the core service, not a side effect. The vehicle is merely the tool. The passenger pays for the driving, not the use of the car. The court put it bluntly, driving is not ancillary. is the main event. Secondly, economic substance is more important. The exclusion under Section 32, subsection 2, subsection A is designed for cases like renting equipment with incidental service, not for an entire business built on providing rides, and Uber is one of them. Number 3, precedents alignment. This view aligns with earlier cases like Thomas and Nas and Optical Superstorm, which stress that where the human service dominates the transaction, ancillary exemptions don't apply. This reasoning draws a bright line between using an asset and delivering a service through human effort. Driving, said the court, is labor-centric. The car is incidental. That's a sharp contrast with Uber's technology narratives, where the app, data, and vehicle ecosystem supposedly take central stage. So in one stroke, the court asserted that human work, not digital intermediaries, remains the taxable core of the platform labor. What's the takeaway? Well, the ruling clarifies that where labor is the dominant force that drives value, tools or equipment, even cars, don't turn the service into something ancillary. For gig platforms, that's crucial. Human effort remains the taxable heart of your businesses, even in a tech ecosystem. Now let's zoom out. When Australia's payroll tax laws were written, the contractor provisions targeted old school arrangements, bricklayers, delivery drivers, medical specialists, but not app-based work. But technology has outpaced the statutes. This case shows courts are now stretching old legal fabric to fit the gig economy. So what does it mean in practice? For businesses, digital platforms can't assume they are exempt from payroll tax. The court's broad reading means revenue authorities will likely audit rideshare, food delivery, and even freelancing apps. For drivers and workers, well, this decision doesn't make drivers employees. It reinforces that their work is integral to Uber business. That could influence future debates on superannuation, insurance, or employment rights. For policymakers, the tension between innovation and regulation is now crystal clear. If gig work doesn't fit existing tax law, maybe it's time for legislative reform. So what's the conclusion? And what did we learn? The New South Wales Court of Appeal didn't just decide a tax case. It redefined how we see work itself. So next time when you order an Uber, remember that 5-star ride is more than just a tap on an app. It's also a live experiment in how 20th century tax laws grapple with 21st century business models. Now let's conclude this video. Drivers supply services to Uber, not just the passengers. Driving is the core service, not an ancillary to using a car. Payment to drivers are for or in relation to work, even through an app. It's a clear message. Platform can't hide behind digital layers to avoid real-world obligations. It is foreseeable, however, that Uber will inevitably revise its agreements with drivers. A game of cat and mouse between the new economy and old wisdom has only just begun.